Well, the Supreme Court has ruled that the RCMP had the right to ask a reporter to provide them with his notes from an interview with a suspected ISIS terrorist. Ben McCoo, a journalist for Vice Media, had refused to give that information and argued that providing it effectively turned journalists into an investigative arm for the police. But in a unanimous decision, the Supreme Court today ruled that the RCMP had fulfilled 9 conditions that the court had set out in a previous ruling for the reasonableness of a search and seizure of media material. Martin O'Hanlon is the president of CWA, and that's an organization representing media workers across the country. Martin O'Hanlon, thanks for taking the time to speak with us.
My pleasure, Mark.
Okay, the Supreme Court, when you get to the heart of what it ruled today, it said, first of all, the need to protect society outweighed journalistic rights. It said a whole series of reasonableness criteria, 9 of them, were met by the RCMP, and that it said that this request for notes didn't reveal an unnamed source, and it didn't violate an off-the-record conversation. So everyone knew this terrorist identity. How do you respond to what the court's ruled today?
Well, I mean, I obviously disagree. I mean, they ruled on some certain legal principles, but let's get right to the crux of it. And the crux of it is, it's this sort of the balancing equation, and that is, does the public safety outweigh the freedom of the press? And in my view, the onus has to be much more heavily on authorities and the police to justify why they can overrule freedom of the press if they're going to win this case. The judges obviously disagreed. They thought that the RCMP made a fair enough case. But, you know, when you're going to trample on a charter right, you better have a really good reason to do it. And in this case, you know, the guy who was in question, the alleged terrorist, we don't even know where he is now. He's probably dead. There's been no harm to public safety shown that we know of. So, you know, they've trampled over the freedom of the press with really no suggestion that there's been any harm to Canadian society.
Okay, I guess that leaves a question then. This is the highest court of the land. They have set jurisprudence with this. What alternative does that leave? Where do things go from here? Yeah,
I mean, you know, we have nowhere to go in the courts. From now on, it's going to be, obviously, every case is going to have to be put before a judge. But I think that the next step we have to take is to try to pressure the government to further bolster the Journalist Source Protection Act, which was just passed in October, by the way, which this case did not even get into. But I think they need to put in stronger language that will put in the onus more on authorities as opposed to on journalists. Now, you know, is that possible? That's certainly going to be an uphill fight. But you know what? This is much too important an issue for us to give up. So we're going to be fighting and pushing the government at every turn to strengthen that act. And when it goes to the courts, we'll fight again if we have to try to protect journalist sources.
Okay, Martin O'Hanlon, thank you very much for speaking with us.
My pleasure.